right, folks, we should be live. All right, welcome to Gamcast for Monday evening. Sorry, I've not been putting out as many videos. I've had some health issues and really busy at work, but I should be back to normal and putting out videos a little bit more regularly here. Today, we're here to talk about what happened with the Supreme Court. It denied certiorari in two cases concerning the Second Amendment. One out of Maryland, which I have pulled up here, Snoke v. Brown, and the other out of Connecticut. The Connecticut one dealt with large magazines. The Snoke v. Brown is a little bit more consequential because it dealt with AR-15s in general. So as we all know, the Heller case, District of Columbia versus Heller, they had basically a complete gun ban. It was just completely nuts. I mean, you were allowed to own a firearm, but it had to be disassembled. And anyway, it was just kind of crazy. And so it was an easy case for the Supreme Court to come in 2008 and basically declare the Second Amendment means what it says. And the states cannot ban firearms. Well, since that time, a lot of these, fascist Democrat states have come along and passed different kinds of gun bans that clearly go against Heller. They're just nutty. The one banning this one in Maryland, in Maryland, bans all AR-15s. But I wanted to use this as tell you a couple things. First and foremost, how do you get cert? Okay, you need 4 justices. And what happened today is kind of odd because I'm looking at the denial here. If you look here, you can see this is just denial of cert petitions as far as the eye can see. And then in some of them, the court takes usually they just deny it with a one-liner. But here they wrote. And so you can see here the petition for writ of certiorari is denied. You need 4 of the 9 justices for the court to take the case. The Supreme Court, except in rare instances, for example, disputes between states, is not a court of original jurisdiction. That is, you get to it, you go to a district court, you do have a right to appeal to a circuit court. There are 13 of those, and then you have to ask the Supreme Court to hear the case. If 4 agree to hear the case, the certiorari is granted and you hear the case. Here they didn't get 4, they got 3. Alito, Gorsuch, and Thomas, who wrote separately, we'll get to him in a minute, said they would have taken the case. Kavanaugh says, interestingly, he talks about this case. He talks about Heller. He talks about, at the end here, in short, under this court's precedence, the Fourth Circuit's decision is questionable. So this idiotic law was upheld at the district court. It was upheld on the Fourth Circuit Court of Appeals, right? He says it's questionable, right? And he talks about whether this issue should be revisited. He goes, opinions from other courts of appeals should assist the court in the ultimate decision-making. Additional petitions for certiorari will likely come before the court shortly. And in my view, this court should and presumably will address the AR-15 issue soon. So I'm not sure what we're waiting for here, Justice Kavanaugh, but here's my best guess. My best guess is he doesn't like the facts of the Maryland case, right? Whoever it was that challenged the law, probably not a good actor. They're probably looking for somebody, they say in law school, bad facts make bad law. They're probably looking for a really, really sympathetic plaintiff. Let me get to Thomas and then we'll cut for the day. So Thomas, basically, as per usual, he's the best Supreme Court justice. I can't believe we fell for the whole, he wasn't a bright guy, I think, because he's by far the best. But anyways, I would not wait to decide whether the government can ban the most popular rifle in America. The question was of critical importance to tens of millions of law-abiding AR-15 owners throughout the country. Anyway, and he also says, until we remain vigilant in enforcing the Second Amendment, the right to arms will remain a second-class right. And he's exactly right. So my guess is they're waiting. They got tons of these cases coming because the Democrats are crazy. They can't control themselves. They keep passing these laws everywhere. So they got a bunch of them down the pipeline. I expect we'll see something soon. And I fully believe, without hesitation, that the Supreme Court will overturn certainly the magazine limits and the AR-15. But we shall see. But I want to leave on this note, just another note. For those of you, every time you hear, the conservative Supreme Court, the superlative Supreme Court, remember cases like these. I say this, but I'm blue in the face. The Supreme Court is not conservative. Never has been in my lifetime. I think it's center left, but you could make an argument it's kind of like a little bit moderate, like a little center right. But the idea that it's conservative is nonsense. If it were conservative, it would take every one of these cases up and slap these states right between the eyes for they're violating the law, and brazenly at that. So anyway, if you enjoyed this, please take a moment and subscribe, like, comment, share. And by the way, I do read the comments. Somebody left one a couple of days ago. It was really, really a great comment, and it really, really does get you enthused to do this stuff because it's not easy. But anyway, if you do that, you will see me on the next one, which will probably be Wednesday.